Welcome to the deep dive. Today we're plunging into civil procedure. It's often seen as, the backbone of the legal system. If you're studying a law, or especially if you're gearing up for something as formidable as the bar exam, understanding these rules isn't just about memorizing facts. It's really about seeing how the entire machinery of justice, well, operates. Our goal today is to cut through some of that complexity and give you the vital insights, the things you really need to confidently tackle this subject, whether that's for a tricky essay question or a multiple choice problem.
That's exactly right. Civil procedure, it governs every single step of a lawsuit.
Yeah.
From the moment that complaint hits the clerk's desk right through to the final appeal. And for anyone prepping for a legal exam, grasping the why behind these rules, how they connect to bigger ideas like due process and judicial efficiency, that's what's really critical. This deep dive, it's specifically tailored to build that kind of comprehensive understanding, to equip you not just to spot the issues, but to analyze them thoroughly, articulate your reasoning clearly. That's exactly what you need for those challenging legal essays.
Absolutely. We've got a really comprehensive review from a top legal resource guiding us today. We're going to pull out the most high-impact nuggets, definitely highlight the common pitfalls, the things that trip people up, and hopefully by the end of this, you'll feel genuinely well-informed, ready to apply these concepts with real confidence. So let's just jump right in. Okay, let's unpack this foundational concept. Jurisdiction. It's fundamentally about, a court's power, its authority to even hear a case in the first place. And when we talk about jurisdiction, we immediately hit two really big ones: subject matter jurisdiction and personal jurisdiction. For something like the bar exam, why is understanding the fundamental difference between these two just so crucial? What's the core distinction we absolutely need to nail down right from the start?
Yeah, that's a fantastic place to begin because that distinction is absolutely critical. Think of it like this. Subject matter jurisdiction, SMJ, is all about the court's competence to hear this specific type of case. Does a family court handle major criminal trials? No. Does a federal court usually hear a simple state contract dispute, unless there's some kind of specific federal hook, like diversity? Generally, no. It's about the court's authority over the subject of the dispute itself. And here's the really crucial insight, the one that gets tested all the time. Unlike personal jurisdiction, SMJ cannot be waived or agreed to by the parties. You can't just say, oh, we agree this court has SMJ. Nope. A court can even bring up the lack of SMJ on its own at any point in the litigation, even years later on appeal. And why is that? Because SMJ touches on the inherent limits of a court's power, often set by the Constitution or by Congress. It protects that careful balance of power between our federal and state court systems. If a court lacks SMJ, any judgment it issues is essentially void. You just cannot give a court power it fundamentally doesn't possess under the law.
Okay, so SMJ is about the type of case, and it's non-waivable.
Got it.
Right. Now, within the federal court system, you're primarily going to encounter two main types of subject matter jurisdiction: federal question jurisdiction and diversity jurisdiction. Let's take federal question jurisdiction first. The core idea here is pretty straightforward. Federal courts have original SMJ over civil actions that arise under the U.S. Constitution, federal laws passed by Congress, or U.S. treaties. These are cases where the plaintiff's actual right to get relief comes directly from federal law. Think civil rights claims under federal statutes or patent and copyright infringement cases. Now, most federal question claims can actually be heard in both state and federal court. We call that concurrent jurisdiction. But sometimes Congress decides to make federal jurisdiction exclusive. For example, certain patent and copyright cases, some bankruptcy proceedings, those have to be filed in federal court. State courts just don't have the authority.
Okay, so federal law issue equals federal court, usually. But what's this well-pleaded complaint rule you mentioned? That sounds like something designed to be tricky on an exam. Oh, it absolutely is. This is where it gets really interesting and, frankly, a bit counterintuitive for exam takers. The well-pleaded complaint rule means that for federal question jurisdiction to exist, the federal issue must appear on the face of the plaintiff's properly pleaded complaint. It has to be part of the plaintiff's actual cause of action. It's not enough if the federal issue comes up in the defendant's answer, or as a defense, or in a counterclaim. It has to be integral to the plaintiff's claim itself. Imagine this common bar exam scenario. Plaintiff sues in state court purely for breach of contract to state law claim. The defendant's only defense is that a federal statute preempts the contract claim. Even though a federal issue is now central to the whole dispute, that federal defense doesn't suddenly create federal question jurisdiction allowing removal to federal court. The plaintiff's initial claim didn't arise under federal law. That's a critical, critical distinction.
Wow, okay. So it really matters who raises the federal issue and where it appears in the pleadings. That's definitely something to watch out for. What about the other main type, diversity jurisdiction?
Right, diversity jurisdiction. This type of SMJ exists primarily to provide a neutral forum for litigants who are from different states. The theory is it protects out-of-state parties from potential local bias in state courts. It has two absolutely strict requirements, and both must be met. First, diversity of citizenship. This means the opposing parties must be citizens of different states, or you might have a citizen of a state versus a citizen or subject of a foreign country. Second, the amount in controversy must exceed $75,000. Notice the word exceed. It has to be at least $75,000 in one sense. Exactly $75,000 is not enough.
Okay, different states and over 75K. Seems simple enough, but I bet there are nuances.
Oh, definitely. A key point often tested is the timing. Diversity must exist at the exact time the complaint is filed with the court. It doesn't matter if, say, a plaintiff moves to the defendant's state the day after filing. Jurisdiction, once it properly attaches at the moment of filing, generally isn't destroyed by later events, like a change in citizenship.
Got it. File date is key. What about this complete diversity thing?
Yes, the general rule for diversity is the complete diversity rule. This means there's no diversity of citizenship if any plaintiff is a citizen of the same state as any defendant. Think of it like this. No plaintiff on one side of the V can share state citizenship with any defendant on the other side. This is a really common trap on exams. You could have, say, 10 plaintiffs from 10 different states suing 10 defendants from 10 other states. Looks diverse, right?
Right.
But if just one of those plaintiffs happens to be a citizen of the same state as just one of those defendants, boom, complete diversity is destroyed, and there's no diversity jurisdiction under the general rule.
Wow. Okay, so one overlap ruins it. Are there exceptions?
Yes, thankfully. There are some important statutory exceptions where only minimal diversity is required. That just means at least one plaintiff is diverse from at least one defendant. The big ones to know are cases under the Federal Interpleader Act, the Class Action Fairness Act, CAFA, which applies to large class actions, usually over $5 million in controversy, and at least 100 members, and certain interstate mass torts, like a plane crash involving victims and defendants from many states. The policy behind these exceptions is usually about efficiency handling these complex, multi-party cases in one federal forum instead of scattered across many state courts.
That makes sense. Now, figuring out the actual citizenship of different parties sounds like it could get complicated too, especially with businesses.
It really can. And getting the citizenship rules right is vital for any diversity analysis, especially in an essay. For an individual, a natural person, citizenship means their domicile. Domicile isn't just where you live. It requires two things: your physical presence in a state and your intent to remain there indefinitely. You can only have one domicile at a time. And for diversity purposes, a foreign citizen who is admitted to the U.S. as a permanent resident is treated as a citizen of the U.S. state where they are domiciled. Now, for a corporation, it's different. A corporation is considered a citizen of every state where it is incorporated and the one state where it has its principal place of business. The principal place of business is usually its headquarters, the nerve center, where the high-level decisions are made. So, a company incorporated in Delaware but headquartered in California is a citizen of both Delaware and California for diversity purposes. That "and" is key.
Okay, so corporations can have two state citizenships. What about partnerships or LLCs?
Unincorporated associations like partnerships, LLCs, unions, they're treated differently again. For diversity, an unincorporated association is considered a citizen of every state where any of its members are domiciled. So if you have an LLC with members in New York, New Jersey, and Florida, that LLC is considered a citizen of New York, New Jersey, and Florida. This makes it much harder for unincorporated entities to get into federal court based on diversity, because they carry the citizenship of all their members. For a legal representative, like an executor of an estate or a guardian for a minor, the representative's own citizenship generally controls for diversity. However, there are exceptions. If the representative is for a decedent's estate, you look to the decedent's citizenship. If it's for an infant or incompetent person, you look to the infant's or incompetent person's citizenship. And finally, for class action members, thankfully, you generally only look at the citizenship of the named class representative to determine diversity against the defendants. This really simplifies things for large class actions under the standard diversity rules.
That's a lot of detail on citizenship. What about the other piece, the amount in controversy, the over $75,000 rule? How does that work, especially if there are multiple claims or parties?
Good question. For the amount in controversy, the plaintiff's good faith assertion in the complaint that the claim exceeds $75,000 is usually enough.
The court will generally accept it unless it appears to a legal certainty that the plaintiff cannot actually recover that amount. It's a pretty lenient standard for the plaintiff initially. Where it gets interesting is with aggregation of claims. The rules here are specific. A single plaintiff can add together or aggregate all of their claims against a single defendant, even if the claims are unrelated, to meet the $75,000 plus threshold. A single plaintiff can also aggregate claims against multiple defendants only if those defendants are jointly liable in the claim. Multiple plaintiffs, however, generally cannot add their separate and distinct claims together to meet the amount, even against a single defendant. The main exception is if the multiple plaintiffs have a common and undivided interest in the claim or the property at issue.
Can you give an example of that? Common and undivided interest.
Sure. Imagine two people separately injured in the same car accident, each claiming $50,000 in damages. They can't aggregate their claims to get over $75,000 because their injuries and claims are separate. But if two people jointly own a piece of artwork worth $80,000 and they sue someone for destroying it, they can aggregate because their interest in the artwork was common and undivided. And generally, counterclaims filed by the defendant don't count towards meeting the plaintiff's initial amount in controversy requirement to get the case into federal court. A compulsory counterclaim might get supplemental jurisdiction, but a permissive one usually needs its own independent SMJ, including meeting the amount in controversy if it's based on diversity.
Okay, that clarifies aggregation. Are there ways parties try to, let's say, strategically manipulate diversity, like assigning a claim just to create it?
Courts are definitely aware of potential strategic devices. While a party can genuinely change their domicile before filing suit, even if a motive is to create diversity, actions that are deemed, quote, improperly or collusively made or joined to invoke the jurisdiction of the federal court are prohibited by statute. So, for instance, assigning a claim to someone purely to manufacture diversity, where the original owner retains the real interest, would likely be seen as improper collusion and wouldn't work. Courts look at the substance of the arrangement.
So we've covered cases starting in federal court based on federal question or diversity. But what happens when a federal court does have jurisdiction over one claim, maybe a federal question claim, but there are other related claims, perhaps state law claims or other parties involved that don't independently meet those federal requirements? This sounds like a really common scenario, maybe ripe for a bar exam question that mixes state and federal issues.
Absolutely. This is exactly where supplemental jurisdiction becomes essential. It's codified in federal statute 28 U.S.C. section 1367, and it's all about judicial efficiency and economy. The core idea is to allow a federal court, which already has proper original SMJ over at least one claim, to also hear additional related claims in the same lawsuit that wouldn't, on their own, have an independent basis for federal SMJ, like a state law claim between non-diverse parties with less than $75K at stake. The critical test is that these additional claims must arise from the same common nucleus of operative fact as the claim that does have original SMJ. Basically, do they all stem from the same underlying incident or transaction? Are they part of the same overall constitutional case or controversy? If so, supplemental jurisdiction might allow the federal court to hear them all together.
Okay, common nucleus of operative fact. How does that apply differently depending on whether the original claim was federal question or diversity?
That's the key distinction. If the original claim that got the case into federal court is based on federal question jurisdiction, then supplemental jurisdiction is generally quite broad. As long as any additional state law claims meet that common nucleus test, the federal court usually has discretion to hear them, even if they involve different parties. Think of a federal civil rights claim, and tack onto it is a related state law battery claim arising from the same incident. The court can likely hear both.
Makes sense for federal question cases, but you said it's different for diversity cases.
Yes. When the only basis for original federal jurisdiction is diversity jurisdiction, the supplemental jurisdiction statute, section 1367B, puts significant restrictions in place. This is where you need to be really careful on an exam essay. While the common nucleus test still needs to be met, supplemental jurisdiction generally cannot be used for claims asserted by the original plaintiffs against parties who are brought into the lawsuit later through rules like impleader, Rule 14, compulsory joinder, Rule 19, permissive joinder, Rule 20, or intervention, Rule 24, if exercising jurisdiction over those claims would destroy the complete diversity that was required for the original diversity jurisdiction. This is basically designed to prevent plaintiffs from doing an end run around the complete diversity rule established in Strawbridge v. Curtis.
Can you walk through an example of that limitation?
Sure. Let's say plaintiff, NY, sues defendant, CA, in federal court based on diversity. The amount is over $75K. Okay, we have SMJ. Now, defendant CA pleads a third-party defendant, TPD, from NY, claiming the TPD is liable to the defendant for whatever the defendant owes the plaintiff. Supplemental jurisdiction likely covers the defendant's claim against the TPD, but if the original plaintiff, NY, then tries to assert a direct claim against the third-party defendant, NY, supplemental jurisdiction generally won't cover that claim because plaintiff NY and TPD NY are not diverse, and allowing this claim would destroy complete diversity. The statute explicitly prohibits this in diversity-only cases for claims by plaintiffs against parties brought in under Rule 14, Impleter. Similar restrictions apply to claims by plaintiffs against parties joined under Rules 19, 20, and 24, and claims by persons seeking to join as plaintiffs under Rule 19 or intervene as plaintiffs under Rule 24 if it breaks complete diversity.
However, these restrictions in Section 1367B generally don't apply to compulsory counterclaims or cross-claims, which usually do fall under supplemental jurisdiction even in diversity cases, as long as they meet the common nucleus test. It's a complex area, but crucial for multi-party diversity scenarios.
Okay, that makes the restriction clear. It's mainly about claims by plaintiffs that would break diversity. So we've covered getting into federal court initially and pulling in related claims. But what about the reverse? Cases that start in state court and then a party, usually the defendant, wants to move it to federal court. That sounds like removal jurisdiction.
Exactly. Removal jurisdiction is the statutory right, primarily for defendants, to move a case from state court to the federal district court that geographically embraces the state court where the case was originally filed. The general rule, under 28 U.S.C. Section 1441, is that a civil action filed in state court can be removed by the defendants if the federal court would have had original subject matter jurisdiction over the case had the plaintiff filed it there initially. So you basically ask, could this case have been brought in federal court in the first place based on federal question or diversity? If yes, it's generally removable. And as I mentioned, the removal must be to the federal district court for the district and division embracing the place where the state action is pending. Removing to the wrong federal court is a procedural defect.
So if it could have started in federal court, it can usually be moved there by the defendant. Are there special rules, maybe for diversity cases again?
Yes, there's a very important limitation specifically for diversity-based removal. It's often called the forum defendant rule, found in Section 1441b2. This rule states that if the only basis for federal jurisdiction is diversity, the case cannot be removed if any defendant who has been properly joined and served is a citizen of the state where the action was originally filed. The idea is to prevent a defendant from removing a case to their home state federal court when they're already being sued in their home state court. The rationale for diversity, avoiding local bias, doesn't really apply there.
Example time.
Sure. Plaintiff California sues Defendant 1, New York, and Defendant 2, also New York, in New York State Court. The amount exceeds $75K. Plaintiff CA is diverse from both defendants, and why? Can the defendants remove based on diversity? No, because both defendants are citizens of New York. The forum state, the forum defendant rule bars removal. But note this rule only applies if jurisdiction is based solely on diversity. If there's also a federal question claim in the case, the forum defendant rule doesn't block removal based on the federal question. And if federal question claims are joined with state law claims that aren't independently removable, the entire case can generally still be removed, though the federal court might later remand the purely state law matters.
Okay, the forum defendant rule is a big one for diversity removal. What about the procedure? How does removal actually happen?
The procedure involves filing a notice of removal in the appropriate federal district court. There are strict timing requirements. Under Section 1446B, the notice must generally be filed within 30 days after the defendant receives the initial pleading, like the complaint or summons, or within 30 days of receiving an amended pleading or other paper from which it first becomes apparent that the case is removable, e.g., if a non-diverse defendant is dismissed, creating complete diversity. And here's another point that frequently catches people. Generally, all defendants who have been properly joined and served must join in or consent to the removal. Unanimity is usually required.
Unanimity.
Except the main exception is if removal is based on a federal question claim under Section 1441A, some courts hold that only the defendants against whom that federal claim is asserted need to consent. But the general rule is unanimity. Also, for actions based solely on diversity, there's an absolute outer time limit. Removal generally cannot occur more than 1 year after the action commenced in state court, unless the plaintiff acted in bad faith, like fraudulently joining a non-diverse defendant just to prevent removal to keep the case from being removed earlier. This 1-year limit is firm, absent bad faith.
30 days, unanimity, 1-year cap for diversity, lots of procedural hurdles. What happens if removal was improper? Can the plaintiff send it back to state court?
Yes, that process is called remand. If the federal court determines at any time before final judgment that it lacks subject matter jurisdiction, it must remand the case back to the state court from which it was removed. Remember, SMJ is non-waivable and essential. For other defects in the removal procedure, like missing the 30-day deadline, violating the forum defendant rule, or lack of unanimity, the plaintiff must file a motion to remand based on these procedural grounds within 30 days after the notice of removal was filed. If the plaintiff doesn't object to a procedural defect within that 30-day window, the objection is waived. But again, an objection based on lack of SMJ can be raised by anyone or the court itself at any time.
Okay, that covers getting the case into the right court system, state or federal, and handling claims within it. But that's only half the battle, right? The court also needs power over the actual people or property involved. That brings us to personal jurisdiction.
Exactly. Now we shift from what kind of case can this court hear, SMJ, to does this court have power over this specific defendant or this specific property? That's personal jurisdiction, PJ. And here's that critical distinction again. Unlike SMJ, PJ is considered a personal defense and can be waived by the defendant. If a defendant doesn't object to PJ at the first opportunity, either in a pre-answer motion under Rule 12b, or in their answer if they don't file a pre-answer motion, they generally waive the defense and consent to the court's jurisdiction over them. This waivability is a huge difference from SMJ and a frequent testing point.
So PJ is waivable. What are the different types or bases for a court to have personal jurisdiction?
Broadly, we talk about in rem jurisdiction, power over property located within the state to determine rights in that property against the whole world. Quasi-in rem jurisdiction, power over property to determine rights of specific persons concerning that property, or using property as a basis to assert jurisdiction over the owner, but limited to the property value. And the most common type, in personam jurisdiction, power over the defendant personally, allowing a judgment for damages or injunctions that binds the defendant directly. Let's focus on in personam. There are several traditional bases for in personam jurisdiction. First, if a defendant is voluntarily present in the forum state and is served with process there sometimes called tag jurisdiction that generally establishes PJ, even if their presence was brief and unrelated to the lawsuit, though there are exceptions for being tricked or forced into the state. Second, domicile. A state always has general personal jurisdiction over individuals who are domiciled within its borders, even if they are temporarily absent when served. You're always at home in your domicile. Third, consent. The defendant can explicitly consent to PJ, maybe through a forum selection clause in a contract, or implicitly, like by driving on the state's roads, implied consent statutes for non-resident motorists, or, as we mentioned, by voluntarily appearing in court and litigating without properly raising a timely objection to PJ. A general appearance waives the PJ defense. Fourth, state long-arm statutes. Every state has statutes that allow their courts to exercise jurisdiction over non-residents who perform certain acts within the state, like transacting business, committing a tortious act, owning property there. These statutes often authorize jurisdiction up to the limits allowed by the Constitution's Due Process Clause. And finally, sometimes attachment of property within the state can be a basis, but for claims unrelated to the property, quasi-in rem type 2, the Supreme Court case Schaffer v. Heitner held that you still need the defendant to have sufficient minimum contacts with the forum state. Just owning property there isn't automatically enough anymore for unrelated claims.
Okay, those are the bases. You mentioned due process and minimum contacts. That sounds like the constitutional overlay on all of this, especially for non-residents.
Exactly. The Due Process Clause of the 14th Amendment sets the outer boundary for exercising PJ, particularly over defendants who aren't physically present or domiciled in the state. The landmark case, International Shuko v. Washington, established the modern framework. Due process requires that for a state court to exercise PJ over a non-resident defendant, that defendant must have sufficient minimum contacts with the forum state, such that maintaining the suit there does not offend traditional notions of fair play and substantial justice. It's a two-part analysis: contacts and fairness.
Minimum contacts, what does that actually mean in practice?
It means the defendant's connection with the forum state must result from their own purposeful availment. The defendant must have deliberately reached out and engaged in activities within the forum state, invoking the benefits and protections of its laws, making it reasonably foreseeable that they might be sued there. It can't be based on just random, isolated, or unintentional contacts, or solely on the unilateral activity of the plaintiff. The defendant must have aimed their conduct at the forum state in some meaningful way.
Okay, purposeful availment. Then you mention specific versus general jurisdiction.
Right. This relates to the connection between the defendant's contacts and the lawsuit itself. Specific jurisdiction exists when the plaintiff's cause of action arises out of or directly relates to the defendant's specific contacts with the forum state. Even a single contact can be sufficient if it's the very thing the lawsuit is about. For example, defendant drives into the forum state, causes an accident, gets sued there for that accident. General jurisdiction, on the other hand, allows the defendant to be sued in the forum state for any claim, even one completely unrelated to their contacts there. But this requires the defendant's affiliations with the state to be so continuous and systematic as to render them essentially at home in the forum.
At home. What does that mean for general jurisdiction?
For an individual, at home means their place of domicile. For a corporation, at home means its state of incorporation and the state of its principal place of business. It's exceptionally difficult to establish general jurisdiction over a corporation anywhere else. Their operations elsewhere would have to be incredibly extensive and pervasive, effectively